Everyone, thank you again for coming. My name is Jeffrey Hornung. I am a fellow at Sasakawa, USA, and also project director for the Maritime Awareness Project at Sasakawa. It makes sense that Sasakawa, USA and MBR would first focus on the Asia-Pacific maritime domain. After all, we are two Asia-focused organizations and enjoy a wealth of knowledge in the region, concerning the region. Within the Asia-Pacific region, the South China Sea has become a central focal point over the past few years due to the increasing amount of friction between states in the maritime space. We care about this because the South China Sea is a main maritime link between the Pacific and Indian Oceans. Its shipping lanes connect East Asia with Europe and the Middle East. A few facts about the South China Sea are worth noting to emphasize its importance and provide rationale for it being the starting point for a Maritime Awareness Project. More than half of the world's annual merchant fleet tonnage passes through South China Sea choke points. Oil that is transported through the Malacca Strait from the Indian Ocean to East Asia is triple the amount that passes through the Suez Canal and 15 times the amount that transits the Panama Canal. The area is home to some of the world's biggest coral reefs and is an important source of fish for regional states. Some estimates indicate that up to 10% of the world's ocean caught fish are from the region. Experts believe that there are valuable fossil fuels as well in the South China Sea, but estimates vary depending on which country's analysts you ask for that information. According to the U.S. Energy Information Administration, hydrocarbon reserves amount to 11 billion barrels of oil and 190 trillion cubic feet of natural gas. While these 11 billion barrels would only power China for about 3 years at current rates of consumption, the natural gas deposits would be enough to power China for about 30 years at current rates of consumption. Finally, the South China Sea is home to a large number of disputes over territory and geographical features and the rights generated from these under international law. These disputes have led to a constant stream of muscle flexing between coast guards and navies, artificial island building, freedom of navigation operations through contested waters, and undue stress on the integrity of the rule of law and established governance at sea. The complexity of these issues make most think that reaching an overall solution is permanently out of reach, or at least waiting until one actor becomes so powerful that it can be resolved by force. But seldom do we seriously entertain whether there are acceptable solutions within reach now. To help us understand the complexities of the South China Sea, we've asked members of our international expert panel representing China, the Philippines, and Indonesia to focus their remarks on the salient issues in the South China Sea dispute for their country and discuss the interests, both political and economic, that are at play. After hearing these, we'll hear about the role of international law in maritime disputes and how it impacts the ongoing maritime disputes in the region. So let me therefore introduce this prestigious panel in order that they will present their remarks. First, Dr. Nong, who's the Executive Director at the Institute for China-America Studies. Dr. Rommel Banlaoi, who's the Director at the Philippine Institute for Peace, Violence, and Terrorism Research. Dr. Shafiah Muhibat, who's the Chief Editor for the Indonesian Quarterly and also affiliated with the Center for Strategic and International Studies in Indonesia. And Dr. Justin Nankivell, who's the Associate Dean for Academics at the Daniel K. Inouye Asia-Pacific Center for Security Studies. If you would like more detail regarding their backgrounds, you receive their biographies, a more detailed biography upon entry. But without further ado, I will turn it over now to Dr. Hong.
Thank you, Dr. Hornung, and good afternoon, everyone. First of all, I'd like to thank NBR and Sasakawa Foundation USA for having me in this international expert group, and especially having me in this panel on the country's perspective. And I think that's a very quite challenging job to present Chinese perspective within 8 minutes. But thanks to Amr Blair, he helped everyone to understand basically what is China's claim, so they will save me 1 minute. And let me just go to the question of what are actually the nature of the overlapping claims between China and also other claimant states. So basically, we have this overlapping claim for sovereignty and have like pending maritime delimitation and also ambiguity of the legal of the status of the islands regimes. And then we have this issue of what might be the effect of particular features in maritime delimitation in the future. And certainly the core issues, I think, between China and also other climate states, actually how to balance the historical rights governed by customary international law and also maritime regimes governed by the Law of Sea Convention, which actually represent the relationship between customary international law and treaty law in this case. And however, there's certainly other issues in this region about, for instance, regional cooperation under Article 123 of UNCLOS, and also about these joint developments by the pending delimitation by Article 7483 of UNCLOS. But all these issues on regional cooperation on joint development have been overshadowed by the lately focuses on the maritime delimitation, especially about the islands regime, and which has relevance to the arbitration case and, between China and the Philippines. That will bring me to my second point of today's talk, because everyone's following very closely about the arbitration case and what might be the impact. And let me to brief you what is China's rationale not to participate in this arbitration case. So I want to start from about the jurisdiction admissibility. And I think China is very skeptical or concerned about whether this arbitration tribunal has jurisdiction. It's based on three aspects. The first one is questioning about whether the Philippines and China has fulfilled the requirement under Article 283 to have sufficient exchange of views before they go to the arbitration courts. And certainly also related to Article 211 and 282 about whether the two countries have agreed to submit their dispute through a bilateral regional documents. And then another very key concept is about the compulsory settlement mechanism under Article 298 of UNCLOS. I think one of the Chinese concerns is that, well, all the disputes by nature is actually about the sovereignty claims and also about the maritime delimitation, and which China excluded in its 2006 declaration from a compulsory third-party forum. I think this is a Chinese argument. And that will bring to another post-arbitration effect on the legal system, because the Law of Sea Convention is like a compromise, a package deal between two interest groups. One is the coastal state and the other is a user state. And Part 15 actually is a compromise for the countries, given countries, on the one hand, they can choose to go to arbitration or ICJ, but on the other hand, they will also give a country's option or choice to opt out of the compulsory mechanism under Article 298. But I think China's concern is that they might have some sort of side effect for the future on the effect or the value of compulsory dispute mechanism settlement. And the second question about why China choose not to participate in the arbitration case, also about the legal culture of China. So in Chinese culture, we don't consider compulsory, for instance, bring your neighbors to ICJ or arbitration is a friendly act. This is a very cultural thing. And the other is also related to Chinese previous state practices of how to solve the problem in terms of international disputes. And see, China is very active in WTO compulsory dispute settlement mechanisms. And China has solved its land boundary through negotiation with 12 its land countries with land border among all the 14 countries, and it has its first maritime demarcation in Gulf of Tonkin with Vietnam. So China think they have previous experience and very good practice of solving the problems through a negotiation. And the last point about arbitration is questioning about what might be the impact of arbitration on the confidence building in this region. And then I would like to go on to, because I'm required to talk about the country's salient issues, and I think I won't avoid talking about land reclamation activities. I think let me just start by to legally speaking, what is the legal basis for China to do the land reclamation activities? So first of all, China has been very carefully selected the location of the land reclamation. It's all within 12 nautical miles of those 7 features. So those features, either they are considered as a rock, and then within the 12 nautical mile territory sea, it's a country's sovereign right and sovereignty to do that. And even though some of the features might be considered by the award arbitration, considered as a low tide elevation, but still located within the 200 nautical mile of the very big features in the Spratly. So they will be governed by Article 60 of artificial construction in a country's claim EEZ. And then what is the legal implication for the Land Reclamation? I think it would not have any constraint to consolidate sovereignty claims and would not have any impact on maritime delimitation. It would not have a constraint to expand maritime jurisdiction. But the things that I do recognize there are a lot of political and implication and see a lot of reaction from international regional communities, and certainly there might be potential environmental risk. I think that's very important for China to prepare environment impact assessment report and make it transparent and as much as possible to the international regional community. And my last point is, what is Chinese perspective in terms of regional dispute management? I use the word management rather than settlement because it's too far from ready for all the countries to solve the disputes or settle the disputes. So I use the phrase of dispute management. I think I'd like to elaborate on two layers. The first one is between the claimant states, including China, Malaysia, Philippines, Vietnam, and Chinese Taiwan. So between the claimant states, I think it's very important to explore different approaches of dispute management. So we have example of a negotiation, and we have example of conciliation, and also confidence building regional approach, such as the process of code of conduct. And then we should also continue to look at the possibility of how to actually implement the concept of joint development. And we have this maritime ASEAN-China Maritime Cooperation Fund, which encourage all these ASEAN member states and China, even it's a landlocked state like Laos, they're able to apply for this funding to conduct any research questions such as like search and rescue or maritime environment protection, etc. And certainly I believe that the third party compulsory forward should be also taken into consideration in the future. But I think one point is very important is it's better to have the mutual consent from the countries. And my last point is about the dispute management between coastal states and user states. Let me take China and US as one example. So it's very interesting, the South China dispute has been developed from the territorial maritime dispute between the claimant states to an issue like it's an issue between China and US, which should not be the case because these two countries actually represent two interest groups, as I said earlier. Like US is the important stakeholder as a user state in the South China Sea, while China is a major claimant state. So I think we do share a lot of common interests like freedom of navigation. So with US increasing presence in this region, also increasing military patrol in the South China Sea, I think we see some very opposite, maybe a strong reaction from China, but it's not driven by legal interpretation. I think we actually we reach consensus that freedom of navigation is very important, but Chinese reactions mostly from political and strategically consideration. So I think how to maintain free navigation, and I think it's one of the fundamental issues between China and US. And some of the very good examples, if you can see from this background, is about, for instance, between China we have this MOU on avoiding accidents at sea and the air, and certainly there will be, we can see a lot of opportunities for expanding the convergence of interest between the two countries and between the two interest groups. Thank you.
Thank you, Dr. Hong. Next, I'd like to turn to Dr. Banlaoi.
Thank you, Dr. Hornung, for the introduction, and thank you to NBR and Sasakawa USA for bringing me back to Washington, D.C. First, I will concentrate on discussing the major turning point in Philippine policy towards the South China Sea, and that is the Scarborough Shoal standoff in 2012. That is a turning point in our foreign policy towards the South China Sea because prior to that incident, the Philippine government has been negotiating for a direct bilateral negotiation with China, particularly when China occupied Mischief Reef in 1995. But when China decided to control the Scarborough Shoal after the standoff, the Philippine government lost patience in talking with China bilaterally, and that prompted the Philippine government to seek for legal arbitration from the International Arbitral Tribunal. with the argument that it's counterproductive for the Philippines to talk to China bilaterally because it did not fulfill its promise of mutual withdrawal from the Scarborough Shoal. And second, we did not want a repeat of another incident in the future because China took control of Mischief Reef in 1995. We discussed with China bilaterally. We had a lot of meetings every year, many times in a year, to discuss it peacefully bilaterally. But we lost our patience in talking to China bilaterally because it took control of Scarborough Shoal in 2012. And that prompted us to submit our case before international court in order to clarify maritime claims of the Philippines and at the same time also clarify the maritime claims of China, particularly the legality of the 9-line claim in the South China Sea. First, I would like to clarify that the Scarborough Shoal is not part of the Spratly, but part of the South China Sea, and it's also within the 9-line claim of China. The Scarborough Shoal is only disputed between China and the Philippines and to a certain extent Taiwan, because the claim of China and Taiwan in the South China Sea is very identical. Other claimants in the Spratlys like Malaysia, Brunei, and Vietnam, they are not party to the Scarborough Shoal standoff. So the Scarborough Shoal is only between China and the Philippines. So that's a turning point in our policy. Instead of direct bilateral negotiations with China, we decided the court to intervene. In fact, we already informed China about our intent to bring this matter to the court, and but we decided to really force the issue because the Philippines, like the United States, we have a very legal culture. And we understand that in China, if you put your neighbor to a legal court, it's like putting your neighbor in the lion's den. Okay, there's a saying in China that in death you have to avoid hell, in life you have to avoid court. But we forced the issue because it's very difficult for us to talk with China, particularly with the new situation in China, where China is a very big power. China is the only major power claimant in the South China Sea, and for a small country like the Philippines, only international law can bring our case peacefully. And for us, bringing the matter to the court is the most civilized and peaceful way. In the Philippines, we sue our father, we sue our mother, we sue our sisters and brothers just to clarify things and to settle disputes peacefully. And that is not being understood in China. For us, international arbitration is not an act of breaking the ties, but it's the most peaceful and civilized way of settling complex disputes like the South China Sea. So that's one. Second, it's a turning point in Philippines-China relations because the Scarborough Shoal standoff and at the same time our decision to bring this matter to the court made our bilateral ties to the lowest moment. This is the lowest moment in our country's bilateral history. In 2005, we just commemorated the golden age of Philippines-China relations. We even signed this joint marine seismic undertaking with China and Vietnam in order to pursue joint development in the South China Sea. But because of the control of the Scarborough Shoal in 2012, our relationship became very, very bitter, and deteriorated very rapidly, and the state of our bilateral relations, at least politically, is really in a very, very bad state. But we hope in the next government and after the arbitration case, we will be able to repair our damaged relationship. And third, it is also a turning point in Philippine-American relations. Because of the worsening situation in the South China Sea, we decided to embrace our alliance with the United States. And so we negotiated with the United States the signing of Enhanced Defense Cooperation Agreement in order to allow increased rotational presence of American troops in the Philippines. And that was signed in 2014, and the Philippine Supreme Court declared that the signing of the Enhanced Defense Cooperation Agreement is not constitutional it's not unconstitutional, so it will be implemented. In fact, just recently, the Philippine government and the United States identified 5 locations where the Philippines and United States can conduct joint military activities, and where the United States can also build their military facilities inside these 5 Philippine bases in order to allow increased rotational American presence in the Philippines. Right now, it's the highest moment in Philippine-American relations, and we decided to embrace our alliance with the United States in order to assuage our fear of a rising neighbor, and that is China. So what's the prospects for a peaceful resolution? For us, the international arbitration is the most peaceful way of settling disputes. But if we cannot settle this dispute through international arbitration, I think the Philippine government is also open to the possibility of opening up another direct bilateral talks with China. But I don't think the negotiation will happen very soon. I think direct bilateral talks will start first on building confidence, because the situation created a lot of mistrust between the 2 countries. Now it's time to rebuild confidence again and talk about how to move forward and pursue the possibility of other peaceful options in order to address the complexities of territorial claims in the South China Sea. But we hope very soon, maybe 3 weeks from now, the permanent arbitral tribunal will announce its decision on the case, and I hope this decision will really clarify things. So I have this another point on the imagery, the island building of China in the South China Sea. That's the crux of our international arbitration case. In our case against China in the area, we want to ask the court to clarify the extent of our claims, because we believe that those maritime features belong to our exclusive economic zone and also belonging to either to our continental shelf. And in our case before China, we are asking the court to clarify whether it is part of our maritime territory. And if it is part of our maritime territory, particularly the concept of exclusive economic zone, we want the court to tell China not to prevent us from doing economic activities in the area, and requesting the court to tell China to remove those structure in those areas, because it belongs to the Philippines. It belongs to the exclusive economic zone of the Philippines, or either the continental shelf, because most of these islands are low tide elevations and therefore part of the maritime domain of the Philippines. But instead of removing those structures, China undermined the legal process by building artificial island, and that is now the strategic dilemma for the Philippines. If we get the approval of the court about our claim, now how can we ask China to remove those artificial islands? It's difficult for us. So we might get legal victory in the international arbitration case, but to get political victory is a major challenge, and that is why we're asking the international community to put pressure on China to respect, uphold, and adhere to the decision of the International Court. Thank you very much.
Thank you very much, Dr. Banlaoi. I'd like to turn next to Dr. Muhibat.
Thank you, Jeffrey. It's an honor for me to actually be here and join this panel and trying to grasp a picture of the complexities of the South China Sea disputes. I think after hearing from colleagues from China and the Philippines, we already get a picture of the complexities of the disputes. But I think it'll be good to start a discussion presenting Indonesia's perspectives by emphasizing on 2 very important points. First, Indonesia remains its position as a non-claimant in the disputes. It has no territorial ambition whatsoever in the area. Nonetheless, it has really great interest at stake. And secondly, Indonesia maintains its continuous advocacy for a more united ASEAN front vis-a-vis China. So all efforts to resolve the issues of the disputes and all efforts to manage the disputes from Indonesia's point of view has to go through an ASEAN platform. With those 2 points as the basis of discussion, it's also interesting to note that in the recent years, there have been incidents or some statements also coming from inside Indonesia's government that raises the questions of whether or not Indonesia has actually changed its position. I think the recent incident just 4 weeks ago, just 4 kilometers off the Natuna Islands, where the Chinese Coast Guard entered the Indonesian EEZ and then meddled with the Indonesia's efforts to stop IUU fishing actions with the Chinese fishing boat. That actually one of the latest incidents that actually again raised the question of whether or not Indonesia has changed its position. As expected, the media made relentless coverage of this incident, and it's easy to understand because once Indonesia changes its position in the disputes, it really changed the whole landscape of how you understand the disputes, with a new actor, the biggest state in Southeast Asia, becoming a direct part of the dispute. That would actually very much change the whole scenery of the dispute. However, even after the recent incident, there were increased tension. And Indonesia sent a diplomatic protest directly to the embassy in Jakarta. And however, after the whole tension a little bit, toned down a little bit, the official statement of the foreign ministry actually placed down the incident by saying that it was all about IUU fishing and Indonesia's effort to combat IUU fishing, and has nothing to do with sovereignty issues whatsoever. So again, Indonesia tries to backtrack from its direct involvement in the disputes by saying that there is no problem with Indonesia's sovereignty in question whatsoever. I guess Indonesia's quote-unquote involvement or claims in the disputes has to go back through way in the 90s, but I think the highlight was in 2009 when China submitted to the UN, a note verbal in which it officially resorted to the now famous 9-dash line. The lines which unfortunately encroach Indonesia's EEZ off the Natuna Islands. So basically, if you look at the map, you look at where the lines meet with Indonesia's EEZ, there is no territorial dispute involved in this. What is involved is the maritime dispute involving Indonesia's EEZ. Now, making a strong response, 1 year after the Chinese note to the UN, Indonesia also presented a note, the same note verbal, by contesting the validity and legality of the 9-dash line and asking for a clarification from the Chinese counterpart. Until now, there has been no response whatsoever from the Chinese, which sort of like strengthened Indonesia's position that as long as there is no response from the Chinese and as long as there is no coordinates published by the Chinese, then there is no Indonesia is not involved in any type of disputes whatsoever in the South China Sea. In fact, Beijing has at least twice had to make statements to acknowledge that the Natuna Islands belong to Indonesia. The incidents last month in March was one of the occasions after which Beijing had to make the statement, strengthening again its understanding that Natuna indeed belongs to Indonesia and has no ambition whatsoever in that particular area of South China Sea. Now, interestingly also, from within Indonesia's government, there are actually some disagreements on how we should treat the South China Sea disputes. If you follow coverages from the media, there are actually some conflicting statements coming from inside the Indonesian government, usually involving statements from military officials and the official statement from our foreign ministry. Now, the government always states that the official statement regarding South China Sea always comes from the foreign ministry. So any other types of comments coming from outside the foreign ministry are basically individual statements coming from politicians. What's interesting, starting in, I think the highlight was in 2014 when there are at least 2 strong comments coming from military officials, including the chief of staff, when he made a statement about Indonesia's threatened by China in the Natuna Islands. And again in 2015, when the president himself made a rather interesting comment during his visit to Japan, where he again publicly stated Indonesia's rejection to China's 9-dash line claim, which interestingly, for only in a few days after he said these comments, he sort of like distanced himself from the comment, making a clarification with a softer tone on what he actually meant by Indonesia's rejection to the 9-dash line. Now, all of these statements coming from outside the foreign ministry have usually always been quickly clarified by another statement coming from the spokesperson of the foreign ministry. Again, usually toning down all the statements, saying that Indonesia is not a claimant in the South China Sea and will remain to be non-claimant in the South China Sea as long as there is no response from the Chinese with regards to the 9-dash line. Now, the question that always arises after looking at these developments is usually whether there will come a time when Indonesia would actually take a stronger stance in the disputes. Something that is frequently suggested. What will it take for Indonesia to actually change its position? What sort of an incident that will be strong enough for Indonesia to change its position? Unfortunately, I don't have an answer to that. Indonesia's foreign ministry is quite confident in the way that it sees China for not allowing something like that to actually happen. The Indonesia's foreign ministry is quite confident that it doesn't have to resort to any sort of like a stronger stance in the South China Sea disputes. In fact, all of these scenarios of what is, have actually never been seriously discussed within the foreign ministry. It has been discussed within the military in a sort of like a non-official basis, but no official discussion or statements whatsoever regarding different scenarios has actually come from the foreign ministry, which shows somewhat their confidence that situation will never come to that. Now, from the second point that I mentioned in the very beginning is that how Indonesia views ASEAN as a vehicle to actually solve the dispute. Indonesia has long been a local proponent of a legally binding code of conduct. It has sponsored a series of dedicated workshops on this issue. It continuously pushes for an ASEAN unity and centrality, as it has been doing since many decades. Now, in 2016, Indonesia continues to do so, even though there are questions whether or not ASEAN is still relevant, whether or not Indonesia has seen itself growing too big for ASEAN. But the official statement coming from the foreign ministry is still that Indonesia is still continues to push for a solution through ASEAN. Now, what's interesting at the moment is actually the foreign ministry is looking to see how things are when the arbitration result comes out. Indonesia is actually contemplating whether or not it will try to pursue a joint statement from ASEAN, which is something that I personally see is very unlikely, looking at the different positions of ASEAN member states, looking how difficult it is from past experiences for ASEAN to actually have a joint statement on anything related to South China Sea issues. But I think we can see statements coming from individual ASEAN states, and Indonesia is trying to craft the most diplomatic and a very supportive statement, whatever the result is. And it is, it's the individual countries' reactions to the result of the arbitration will also be interesting to observe. But like I said, whatever the result is, and I don't think this has actually, no statements whatsoever has come from Indonesia to indicate what its preference is, as with regards to the result. But I think Indonesia will be very supportive on whatever the result is, and will continue to push for a resolution through ASEAN. I think I'll stop here.
Thank you very much. Finally, we'd like to get a legal view on a lot of these disputes, and for that, we'll turn to Dr. Nankivell.
Thanks very much. To Admiral Blair and Richard Ellingson, Dr. Frabel, my sincere gratitude for being part of this. I think the map, as everybody is aware, is going to be a terrific project. It's a fantastic resource. It's timely, and it allows us to do a lot of things with a lot of different materials, and frankly, the scope of this is endless. The scope of the law is not endless, though, so I'll try and get at some key bits in thinking about the law quickly. I'm a bit of a hybrid. I'm a professor, a dean, and I work for the Department of Defense, the United States Department of Defense, so therefore what I'm saying here should not be attributed to the U.S. Department of Defense. It is my own personal capacity within which I speak. I want to touch on three things here today, the first of which is to ask the bigger question about what the role of international law is in this dispute. In other words, to really reframe the package of questions that we ask and we talk about, and fundamentally to ask, what role does law play in these disputes? Secondly, I want to talk a bit about the historical context within which this dispute sits. And it goes back many, many centuries, actually, and I want to locate it there in terms of looking at what the law allows for. And third, I want to touch a bit upon the arbitration. We could talk at length in the Q&A. We could probably talk for days on the arbitration, but I'll give you a few salient bits here. So first, what role does law play in the dispute? I think it's an interesting time to actually be discussing this, in the sense that you can barely open a newspaper on any given day without seeing the law invoked in any write-up of the South China Sea, and you see people writing that the law is being abused and the law is actually in play and somebody's violating the law and the law is confused and it's ambiguous and China's on this side and the US is on that side. So in other words, this really shakes out in a couple of different ways. Most written materials ask what the law is in the dispute, and then they go around and also say the law should be used as a basis for judgment. In other words, if you've got the law on your side, you're acting correctly, you're acting legitimately, legally, etc. If you don't fall within the particular interpretation of the law, you're acting illegitimately, unethically, illegally, etc. Those are sound ways to look at the law, but I'd say they're just a small part of how we want to really evaluate what the role of law is here. And that is, we need to ask the bigger question about how does the law affect states' conduct? And that is a huge open-ended question we've barely scratched the surface on, frankly, in all of the literature and all of the background with international law and international relations. We want to know, how does the law affect Chinese behavior? How does it affect American thinking? Does it bring ASEAN together, etc.? There are a myriad of good questions associated with all of this, and I would encourage the debate, and we'll try and take this up over time within the panel, to think about how the law really does matter. Secondly, I want to just locate this dispute in history. Now, it's not perfectly anchored, but I do want to give you some context here. This is not a new dispute per se. We have been circling through these types of disputes for well over 400 years. And by types, I mean there's a certain variant, there's a doctrinal element that has a strategic component to it that we've been working on literally since the early 1600s. And that's an open seas versus a closed seas debate. That is the distinction that's around, you'll read, since Grotius, of having the seas being open for those to use and ply through and see the resources of being accessible, and the closed seas doctrine. In other words, you could claim sovereignty over jurisdictional boundaries which are quite near the shorelines of states. We've been going through this for hundreds and hundreds of years. The conventions on the law of the sea, the bigger one, obviously the United Nations Convention on the Law of the Sea, tried to reconcile a lot of that and did a very nice job in so doing. And it took us well over 10 years to actually do that. But this South China Sea dispute, I would just point out to you, is about another chapter in this huge debate of open versus closed seas. It's not sharply one way or the other, but we do have arguments that basically shake out on both sides towards these seas being open and available for use, and these seas possibly being closed and available for subjective interpretation as to who might transit through them. So this is not totally novel. This is another series of chapters that will go on for quite a long time. But, and herein lies the big but, the way in which this is shaken out, essentially for the United States and the Philippines and other states, and versus China, and I don't want to use the versus in terms of setting them up, but there are two different axes upon which these disputes rest. And I'll title them here for you, formal justice versus historical justice. So the main crux of the dispute and the main crux of the way in which it's actually being arbitrated and reasoned by the legal teams, and there's legal teams on both sides, is that the United States and the Philippines, and actually let me reverse the order. It's the Philippines and the United States, but a great many other states believe that formal justice, that is the United Nations Convention on the Law of the Sea Treaty, should dictate the terms and the law from which much of this dispute, if not all of this dispute, should be decided. It's the treaty that is the formal source here, and the treaty gives rise to how we think about who has justice on their side and who has the law on their side. Now, the other axis is historical justice. So it's not perfectly clear, and I'll delineate approximately what the Chinese case looks like, but the Chinese case essentially says that China has historic rights and historic types of claims to these waters in certain capacities which precede the treaty in time. Okay, so in other words, these rights were ensconced. This is how the argument probably goes. These rights were ensconced in international law, in customary international law, which, just to make clear, is an equivalent source of law to treaty law, no matter what type of law we're talking about. But these rights for China preceded the treaty, and that therefore the treaty can't trump or supersede rights that were already in place for China. Okay, that's sort of the big picture and how it looks. Now the problem is these two interpretations are like this. They are crossing in the night, and they will never reconcile per se, because we have the treaty strong formal division and historical rights. Now, to go one step further, part of the real core of the argument in the case, the arbitration case, is that historical rights have in some sense been lost by virtue of the way the law has developed. And so it's going to be very difficult for any reconciliation to go forward here because of these very twinned and different perspectives on historical rights, historical justice, and for the formal nature of law. And now the other problem here is that here's another interesting point about how law will come to matter. China believes it has law on its side. China believes it has justice on its side, and these two are fused. And when we start talking about the relationship of law to justice and what's been lost over time in terms of territory and how states, in this case China, may have been removed from participating formally and favorably within the international legal system, that's when we get the sparks for conflict, when justice and law fuse like this. You could argue that many of the other states see themselves as having law and justice on their side, and that's where we enter into a very dangerous territory, I would argue. The arbitration, much can be said and we can talk about it. I think there's a couple of interesting bits that I just want to tease out quickly. The judges for the case, I think, are fair to be characterized as very progressive. I think as well, it's also worth noting, these judges really, to my mind, as someone who's trained in law in Europe, have a very European bent to them. A lot of the European mindset has to do with the law being a tool through which we can solve disputes. That's the law's purpose. In other words, the law is going to, and has been in European thought for hundreds of years, as being a useful solution to get us around the problem of war, armed conflict, tensions between states. The law and institutions can take us on this path. Now, it's not definitive that this is the way the judges would use law in this case, but they really do in Europe and beyond in the law of the sea context. Think about the law as a useful set of tools to bring down armed conflict. And it can't be lost on the judges that this is a terribly difficult time for this dispute. So the judges will be pulled in a whole number of ways. They will want the law to be useful here, but they will also want the law to be complied with, lest this whole version of international law being a fiction, frankly, could be used against them. So they're going to be pulled between what the law requires and what the compliance rates could be seen to do as well. The interesting part is the questions the court has been asked are very specific, and I'm sure many of you know them. The court's not being asked to find out who owns what. That would have been a terribly different road to take in this case. The court has very brilliant lawyers, the Philippines legal team, we should point out, has some of the best lawyers in the world, frankly, at this case. They know exactly what they're doing here. They have threaded the needle very sharply. They have asked the court to talk about in other words, what is what in an area? Is it a rock? Is it an island? Should we consider it an underwater feature? Is the Scarborough Shoal as such? The big fundamental question, does the Philippines have exclusive economic zone rights akin to what the treaty would provide for? And to what extent can we talk about the legality of the 9-dash line? Those are very sharply framed questions to try and get a very distinct legal response in all of this. And I would say, and I'm sort of a moderate international lawyer, in other words, I sort of move in the middle ground here, that the courts over time have been moving in a very minimalist way. So in other words, we're probably not going to see the judges allow for very expansive claims with regards to what's an island and what's not. In fact, we probably see an outcome here where we may have 4 rocks and 4 undersea features, but it's highly unlikely we'd see any islands emerge from any of this, and that therefore will simplify a lot of what we're talking about in terms of what can be claimed vis-a-vis jurisdictions. Compliance is the million-dollar question here that everybody wants to ask. So we can go all through this litigation, we can spend all this time, there can be diplomatic rows. What does it matter if China has already said it will not comply with the verdict, it doesn't believe, and Nong has laid this out nicely in terms of, what's the point of all of this if the arbitration, the process through which we get there is flawed and didn't take Chinese interests into account. I would just offer you this. Before we talk about whether compliance or not is going to come about, we need to see what the judges are going to say, because they could say a lot of different things here, and they could leave a lot of wiggle room for China to actually demonstrate, were it to be required, what a historical claim might look like. So it's not black and white yet. It depends on what the court asks China, frankly, to do in this case. Now, maybe that's the optimistic version. A couple of ways to think also about Chinese compliance is to first ask the question of whether China feels it is bound by the law. Now, in this case, I think it's fair to say China doesn't feel as though it's bound by the law, because it's not the body of law being probably worked through the court that China would seek here. There's a lot of reputational costs that China is probably willing to bear, certainly internally, but probably externally here, in order to not have the court's decision affect its compliance rate because of political circumstance. So while the jury's out on what China's going to do, it's going to be very difficult probably for China to comply if there's a very strong verdict that's actually reached. Now, that's only part of the story. Another way to think about compliance is enforcement. Would other states come around to actually enforce the verdict or the verdict in part? That's a totally open-ended question at this point. We don't know what ASEAN will do. We don't know what the United States would do, Japan, India, etc. That's a very open-ended question that will have implications on the compliance question. As to why China's not there, I think it's fair to say, at least from my interpretation, China's not at court because China has a terrible legal case. And therefore, if I'm a lawyer for a state and I see that we're going to lose in going to court, I'm not going to take my client to court. That's rule number one in good lawyering. I'm going to take us out of court. And I think, frankly, that's what's going on here, because China would have had an extraordinarily high burden to meet and probably would have lost in some capacity. So there's no upside to China going, and that's why China's not there. But again, then we get into a serious set of questions about what are the implications for not going. For China, for the rule of law, there's been talk, for example, China, would they withdraw from the whole treaty as well? So the implications are very serious depending upon how the compliance question shakes out. Final point, again, South China Sea is not just about the South China Sea. It's about a whole range of things. When we talk about the rights and the law as it applies to the exclusive economic zones, which Nong touched upon, and the real disparity with some states with regards to what you can do in the EEZ, and then the general interpretation of what you can do. In other words, there's a great deal more freedom and latitude with the EEZs. That has implications in all of the world's maritime choke points. So that is a follow-on type case or precedent, depending upon what actually could play out through this case. The other one is the following. This case is grounded, as I mentioned, in some form of historic right or historic title, perhaps for China, and therefore it would involve an internal waters claim. Okay, so just to backtrack, have I got 1 minute? 1 minute. Okay, so I mean, China's basically making one of three claims. Either the line delineates all of the entities within its boundaries, and those are China's, one, or the line delineates historic rights, and by which we're talking about fishing rights, oil and resource gas rights, and freedom of navigation rights, two. These are historic rights China's always had. Or three, the line serves as a point of delimitation were it to actually be required, which is basically an internal waters claim. Now, the second and the third versions are slivers apart, but you notice they're grounded in some form of historic rights. The implications, which point towards the impressive nature of the MAP project, indicate that because we have historic rights claims in the Arctic, in both the Russian and the Canadian cases, how we think about historic rights within this case will have precedence not only in Asia, but in other critical areas in the world as well. And that's why we need to think of them in a more composite whole.
Thank you very much, Dr. Nankivell. This has been extremely enlightening in terms of the complexity, and obviously the case that we'll get a decision on in a few weeks is one of the main threads that we have had in the conversation. I'm going to leave any questions about the case to the Q&A for the audience instead of me asking. I'm going to launch with one question. I'm going to turn to Q&A in a moment, let you gather any questions you may have, and then we'll ask you to go to the sides to ask your questions. But in all of your brief talks, you mentioned the United States, Japan, and external powers. The question I have is, are external powers or non-claimants that are not in the South China Sea, are they helpful or hurtful to the South China Sea disputes? And not just the one that's between the Philippines and China, but I guess in general, including international law as well. Are they helpful or hurtful? I'll start with Dr. Hong.
That's a very good question for a scholar with Chinese background. I think, well, legally speaking, for instance, which is the free navigation, I think all these countries are increasing presence, like India, not even India yet, like Australia and Japan, they're all in the name of free navigation operation. So from legally speaking, it's very hard to challenge because China does not differ from USA on the concept of free navigation. But we do have differences on how to understand the nature of certain types of military activities in a foreign country's EEZ. So China's view is that, well, some types of military activities, for instance, some of them might be categorized as marine scientific research, which needs the permission from the coastal states. And some of the military activities may be considered as intelligence gathering, which also have very similar function as marine scientific research. And some of the military activities might actually have a potential impact on the coastal maritime environments. So China is concerned about those certain types of military activities, but China never said that we're going to challenge U.S. free navigation operation. So from this point of view, although on Chinese internal or domestic law, we do have regulation on innocent, like warships innocent passage, which China require prior notification from coastal states. So we, legally speaking, we don't challenge that. But the implication, I think, mostly from politically and strategically driven. So see China and Philippines, and we all claiming states to this South China Sea. So we're looking, no matter how big, what's the size, we are big or we're small. So we're looking for like equal treatment. So we're looking for like the neutrality from external powers. So although U.S. always say we're keeping a neutrality position on the claims, but we does take position on how a country choose how to solve the disputes. I think this is China's different understanding. So with Japan, which also have legal issues with China in the East China Sea, so it's very rational, very understandable for a lot of the Chinese, especially military persons, to understand with all these increasing external powers presence in the South China Sea, many of the Chinese actually see as a strategy, as a containment. Even you call it engagement and containment on Chinese policy. So from that point of view, I think the external powers' role in the South China Sea, I wouldn't say they are not helpful at all. But I would say at this moment, actually would trigger a lot of concerns and capitalism from Chinese perspective.
Okay. Dr. Banlaoi.
Well, as I said earlier, China is the only major power claimant in the South China Sea. It's not only a regional power, but a rising superpower. And for small countries claimants like the Philippines, it's very difficult to relate with this rising neighbor. So the only solution to deal with China in its growing behavior in the South China Sea is to implement a rule of law, to have something that will uphold a rules-based regime in the South China Sea. And that is one, the expeditious conclusion of the Code of Conduct in the South China Sea in order to bind everybody on how to behave properly, how to uphold good manners and right conduct in the South China Sea. So that's one. And meanwhile, because it's very difficult to have this China-ASEAN Code of Conduct in the South China Sea, the option left for the Philippines is to embrace our alliance with the United States and China's increased military and paramilitary activities in the South China Sea and its island building in the area and its effort to hinder our economic activities in our exclusive economic zone are pushing the Philippines to really involve major powers, not only the United States, but also Japan. We also welcome the role of Australia and even the European Union. We want to internationalize the South China Sea dispute because from the Philippine perspective, the South China Sea is not only an issue between claimants and China, but an issue of the whole world. Like, for example, our claim before international court about clarification on the legality and lawfulness of China's non-dust line. This will serve not only the Philippines, but the entire community of nations. So from the Philippine point of view, our international arbitration case is not only serving Philippine interests, but also serving the interests of the world. Thank you.
Thank you. Dr. Muhibat, you talked about the centrality of ASEAN. Is there a role for external powers here?
I guess looking at from Indonesia's perspective, like I said in my short presentation, that Indonesia advocates all resolution through ASEAN. I guess one aspect of that, one very important aspect of that, is that for Indonesia, then the resolution has to be between ASEAN and China. Now, it doesn't mean that Indonesia rejects the existence or the role of external powers in the region. But directly and specifically with regards to the resolution of the disputes, that it's something, the involvement of external actors is something that Indonesia really tries to avoid. But I do have to agree with Professor Banlaoi when he said that the use of South China Sea is not only for ASEAN and China, it's open to a lot of other countries, not only in the region but also globally. But again, looking from Indonesia's perspective, then that is another set of issue that is not related directly to the resolution of the dispute, in which case it really prefers for it to be only between ASEAN and China.
Dr. Nankivell, this is a court case between, for instance, with the case, it's just Philippines and China. So do external powers here, when they perhaps give their opinions on how they'd like to see the outcome, does that help or hinder the process here?
Well, I think it's an open-ended question. If the question is, how do these external powers help bring about peace or something to that effect, I think, in terms of the law, we'd want more states at this point in time in world history, given the conflictive nature of what's going on here, to side with a legal outcome, irrespective of what that legal outcome was, because we want to get to a reasonable solution where dispute settlement could be used in Asia as it is being used around the world. I mean, for example, if you look at the docket of the International Court of Justice, it's filled with formerly developing states using international law productively in a whole range of different areas, because those states now trust the court and they have sitting judges on the court and jurisprudence is changing. So to have countries comment that the law should prevail is helpful in actually moving the role of law through this dispute and bringing it out of the realm, if you will, of sort of strictly power politics, which I think in the aggregate is helpful for everybody, let alone the correct arguments about the South China Sea has a lot of implications that would apply to all states because of the navigational issues, thinking about resource-based issues, etc.
At this point, I'd like to open it up for Q&A from the audience. If you do have a question, I'd ask you to please make your way to one of the microphones at the bottom of the staircases. And if you could just line up at the mics, and I'll ask you to please state your name, your organization, and provide a brief question. And maybe if we have a number here, it looks like we have two. We'll ask two right away. We'll group them together, and then that will give our panelists time to think about both. So we'll just take these first two questions in tandem. Ma'am?
Thank you. My name is Jean Nguyen with Voice of Vietnamese Americans. Thank you for this presentation. My question is for Dr. Nong Hong. What do you think is China's cost analysis with all the actions that they're taking and moving forward with their firmly claims that almost the whole South China Sea belongs to them, given the presentations of all the experts here, based on the international law? And recently, just last week, China has extended into the EEZ of Vietnam by sending the oil rigs 981 and also fly over the waters of Vietnam, and also continue to escalate many of the provocative actions. I want to bring back one point that you brought up, that China has negotiated many border lines with Vietnam before. And I'd like to make it clear that those negotiations was not true negotiations. Those were coercions. And I talked to many of the Chinese high-ranking leaders, and they said we will negotiate bilaterally with Vietnam if Vietnam agreed to let us have 60% of their whatever they have waters. That's not negotiation by the law.
Okay.
Thank you.
Thank you, ma'am. And then we'll take the second question right away, too, and we'll allow our panelists to think about both of them.
My name is Michael Yehuda, and I'm attached to George Washington University. Is there any mechanism by which Chinese historical claims can be assessed? Because it seems from the evidence the Chinese side has produced is very vague, and it doesn't really conform to at least what I understand to be the usual basis recognized for historical claim. After all, if you go around the region, then that is to say, all the countries that adjoin the South China Sea, you can find lots of influence of India. Many of the countries there have been very much influenced by Hinduism and the Hinduism views of legitimacy, of kingship, and so on. And you can find lots of architecture left by them. I could go on, but what you don't find is Chinese influence, except in Vietnam. And so it seems to me that there needs to be some kind of mechanism by which historical claims can be assessed and can be agreed. Otherwise, it's open to all kinds of countries to assert some kind of historical claim. After all, Chinese armies went deep into Central Asia. Does that give them a claim? If not, why not?
Thank you, sir. So I'll let Dr. Hong answer it first, and if somebody else on the panel would like to address it as well.
Sure. So I would like to combine the first question from our journalist from VOA and also professor from Georgetown University. Yeah. Sorry. About what is Chinese claim and what is the legal basis for historical claims?
The cost analysis.
I know. I try to rephrase your question in a way that's the core issue of your question. So I think it's not true to say that we're trying to claim almost the entire of the South China Sea. We have to make it very clear. Chinese claims are based on for the four archipelagos, based on the principle of territory acquisition under customary international law, which include the concept of first discovery, mapping, and effective administration and control. And so those part of the claim has nothing to do with historical right. It has to be based on the customary international, many of these principles of territory acquisition. And then apart from that, based on the land dominate the sea principle, because China ratified law of intervention in 1996, so China would use those features to claim any maritime jurisdiction governed by law of convention, including Part 2 on the territorial sea and Part 5 and Part 6 on the east and continental shelf. And then back to the question of the historical claims, where there's no very clear definition about what is historical title or historical right or even historical water. So basically, China is exploring the possibility of within the U-shaped line of certain types of historical right, which I emphasize here, which is not exclusive, it's inclusive, meaning that all these countries like Philippines, Vietnam, they all have certain types of historical fishing practices or other types of historical practices in this region, as long as you have evidence to show that you actually have a certain of historical rights governed by customary international law, and everyone has the entitlement to claim his right in the U-shaped line. So I emphasize here the history right that China is exploring is on a non-exclusive basis. And then to the question of the lady about this 981 event, I think if you're talking about the 981 back to 2014, it's within parasite. China does not consider as disputed area. And the later one that you emphasize, it's within the Gulf of Tonkin, where China and the Vietnam has already made maritime delimitation in the intermouth, but we're still in the process of bilateral negotiation how to delimit on the outermost of Gulf of Tonkin. So I wouldn't say Chinese activity is in Vietnamese water. It's a disputed area. That will bring to another question about law enforcement in the disputed areas. And then another question, you're talking about China and Vietnam has never going to real negotiation. Let me remind you of one of that, because before although I'm academic with a think tank, but I also have several experience being invited to the Track 2 or Track 1.5 negotiation between China and Vietnam on maritime cooperation or maritime security cooperation. I wouldn't say there was no real negotiation. I recognize a lot of difficulty because nobody wants to compromise. Nobody wants to set back in terms of sovereignty. So doing all this bilateral negotiation is very interesting phenomena. So all negotiation will start by these Chinese delegates and have delegate will make their statement, and we claim blah, 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 and then this negotiation does not affect our claims. And the Vietnamese have delegation will make the same announcement. So if I remind you of the first maritime boundary between China and Vietnam in the Gulf of Tonkin, the fact is that Vietnamese gain 52% and China only gain 48%. And that will bring back to my other Chinese other state parties in terms of land boundary discussion. I think Chinese parties that as long as we sit down together for a negotiation and China is willing to compromise, especially on the maritime delimitation, not a single country can actually claim the full EEZ or colonial shelf. Sometimes we're located in a semi-enclosed sea, so we don't have enough space for every country to claim the full 200 nautical sea. So we are actually exercising very similar activities in a disputed area.
May I repeat my question? I think you answered the wrong way. My question was, what is Chinese cost analysis with all the actions in the claim of the South China Sea? You see, now Vietnam is trying to join the US, the alliance, ASEAN, even India, Japan, Australia, Singapore, actually the EU, and even Russia. The whole international community are trying to convince you that if China wanted to be a global player, not yet a global power, but global player, then you need to somehow see to it that the whole international community is trying to explain to you this is the global rule of law for you to be a responsible partner. Now, what is China's cost?
If I could just ask you to maybe take this, talk to Dr. Hong after the Q&A.
This is my question, because if she's continued to explain Chinese view of the law the way that she is, then confrontations continue. And this is the exact point why the Philippines has to take China to court. And I echo and I support my Filipino friends and my Indonesian friends, and I hope ASEAN will come together. But I hope whoever from China, from the PRA or PRC, watching this and realize this, that if you think your cost analysis is exceeding your interest, you should think again. Thank you.
Thank you. And I know Dr. Nankivell had a comment as well, and then we have two more questions that are waiting. Very briefly.
Good question, sir. There's mechanisms. China could go to the International Court of Justice. Somebody could take China. China would have to go under its own free will, but you could certainly take a historical claim to the International Court. We have law on the subject. It's relatively clear. You have to prove three things to make a historical waters claim stick. You have to have administered authority over a particular area in a very administratively heavy way. You will have had to have done that, secondly, over a long period of time. And you will have to have had acquiescence from the states that were primarily involved with the claim. So it's a tripartite test, and you have to fulfill all three. And if you're the one who's making the historical claim, the burden of proof is on you. At this point, it appears as though China couldn't even come close to meeting any of the three, frankly. I mean, from the evidence that we've looked at, in very big picture, a lot of the empirics are changing, which makes this a very interesting case, particularly the ones that have been unearthed in the last few years. It wouldn't appear as though China the maps that were servicing around 1900 didn't go any further south than Hainan. And in the mid-1930s, China doesn't appear to be even claiming the Spratlys at that point. So there's no way that history could be proved to be administratively useful to China here, and the acquiescence question appears to be moot as well.
Okay, before we move to the next two questions, we have a quick intervention by Dr. Banlaoi.
Just 1 minute. First, we don't challenge China's historic rights in the South China Sea. In the legal arbitration case, what we are asking the International Court is to clarify whether the 9-line claim of China is consistent with the International Convention of the Law of the Sea, and whether it is lawful. Okay? And if it is lawful, then we will adhere to that. If the court says China's 9-line claim is in accordance with UNCLOS and therefore lawful, if that is the decision of the court, we will abide by it. But if the court says that the 9-line claim of China is not consistent with the UN Convention of the Law of the Sea, we would like to request China that if it has any maritime claims in the area, it must adhere to the provision of UNCLOS. So that's our major point in the international arbitration case.
Okay, I'll take the next two questions now, similar to the previous, just group them. I'll go with you first, sir. Okay, I'll go with you.
My name is Jared Ling. I'm from TechRo, and thank you for the presentations. I think it's unfortunate to hear the statements that Taiwan and the PRC's statement and claims are identical. And actually, if you see that, yes, it's identical because Taiwan and the PRC share the same historical history before 1949. So of course there will be some historical facts that they are the facts. But however, Taiwan's and the PRC's South China Sea claims are way different. And one of the major differences is that Taiwan issued the South China Sea Peace Initiative, and basically that's just put the disputes away and call for the joint cooperation. And but PRC, as you can see, that they are doing a lot of things in the South China Sea, like reclamation, like militarization. This is not what Taiwan is calling for. And so the point that I want to make is that Taiwan's claim is based on its national interest, and it's never identical with PRC. And President Ma many times already mentioned that Taiwan and the PRC will not cooperate on this South China Sea. Thank you.
Okay, thank you, and I'll let anyone comment on that after. Question?
You might want to answer that before mine.
We're going to group them together just in the interest of time. We have 5 minutes left here.
Well, mine specifically for Dr. Banlaoi and Dr. Muhibat, as well as Dr. Nankivell, specifically on the limits of international law and the movement towards whether or not you would have a re-emergent security force from the ASEAN nations that are being forced to deal bilaterally with China. Do you believe that the limits of the international law being based on 400 years of doctrine, coming to terms with modern technology, deep water drilling, environmental and ecological cost from development, island building to be the elephant in the room for this, is there an inevitability, do you think, that of needing a security or a kinetic response in order to deter further expansion in this? It seems that international law has proved to be a tad anemic in this particular case.
This is for these three.
Oh, I'm sorry. I'm Scott DeVary. I'm with DeVary Communications.
Thank you. So panelists, we have about 4 minutes left. If I could ask cooperation and give about a 1-minute response to the two questions, or the comment and the question. I'll start with Dr. Hong.
Well, let me start with the comments from the gentleman about whether China mainland and Taiwan share the same claim. So I don't want to comment on that. I don't know the statement that you're referring to, where's the source from. I think PRC after 1949 basically inherit all the claims from previous government of Republic of China. And in terms of, you mentioned about the East China Sea and also the South China Sea Peace Initiative by Ma Ying-jeou. I think that that's not different from what Chinese former President Deng Xiaoping back in 1980, and he proposed the initiative both in the East China Sea and the South China Sea. The full sentence is like shelving the disputes and let's go in for the joint development. That's the policy China still insisting on and still hoping to have the real implementation of this initiative from all these regional states. So, and also the question is not to me, but I'd also like to comment a little bit on the role of international law. I think international law has a very important value in terms of international dispute settlement, but in a different context, and we also need to consider the political context and also the regional context of a particular case. And then, where China does not appreciate the role of international law, but the things that when we come to a very sensitive issue on sovereignty and maritime delimitation, even in the future, we might consider compulsory, for instance, arbitration or ICJ of international litigation. I think the mutual respect and mutual consent is one of the fundamental principles that China is looking for. Thank you.
Yeah, there are limits to international law. But ironically, all claimants and even parties to the South China Sea all believe that international law is needed in order to address the problem of anarchy in the South China Sea. So even China upholds the principle of international law. But at the same time, because of the recognition that there are limits to international law, even the Philippines is also engaged in a mechanism called power balancing. And that is why in this kind of situation, the Philippines decided to embrace our alliance with the United States with the expectation that the United States will be truthful in its commitment to defend the Philippines in terms of imminent threat in the area. So we are also privy to that situation. And thank you to the intervention about China's and Taiwan's claim. I think you've made a proper nuancing of the claims of Taiwan and the PRC, and that's noted. Thank you very much for the clarification.
On the issue of the limits of international law, I mean, it has to be admitted that there are clear limits of the international law. But specifically on South China Sea, if you look at the cases of the Southeast Asian states, the international law is basically what they have. And it doesn't have the ability to resort to any other possibilities than to actually rely on the use of international law to actually, find solution to the disputes. It cannot resort to issues such as, military capabilities, for example, because they don't have it. In this regard, the limits of international law, even though it exists and it's admitted by the Southeast Asian states, it's something that they will continue to resort to, no matter what.
Very quickly, good question, but again, as I said at the outset, it depends on what you mean by the question, right? So if you say international law is anemic in this case, what are we saying? Are we saying that China won't comply with the law? That's a big question. That's certainly central to it. Will you need enforcement with the law? Does it have to go hand in hand? Without a doubt, right? This is a very tricky case because it involves territorial sovereignty. I mean, the scope and the implications are a very high bar. How could we possibly, though, say the law is anemic if the Philippines is using it, Vietnam has appended part of the case, its own judgment to part of the case, Indonesia might use it. Everybody is making statements in the G7 about the rule of law being central to solving this case. No other state in the world believes the 9-dash line is legal or has said so. So the law, I'm talking big picture here, structures a lot of our debate about what is right or wrong, what we might do in the area, literally, whether we would move ships through the area, how would we conduct ourselves. So that's, I'm sort of foregrounding the idea that we need a little more nuance when we talk about what do these limits really mean beyond compliance.
So everyone, please join me in thanking the panelists for this wonderful discussion.